hear testimony and see documentary evidence, but it's going to basically tell a story. We believe that the evidence is going to show that Mr. Ray is a small businessman who is mistreated by a scammer who had his money stolen from him. And then, just as the business was about to turn the corner and become profitable, he was fired. And that this business was a Chevron, was a gas station, convenience store. You've gathered that, I'm sure, as part of the voir dire process. What you don't know is that the evidence is going to show that these were business partners that joined together to operate this convenience store, and that there was problems with the operations. You're going to hear all about those problems. The evidence is going to show that there's only one solution, and that is to unwind the deal. The evidence is going to show that Mr. Ray is entitled to an award from the jury of $384,904.79, which is the money that he has paid to the three defendants. We are asking you to unwind that deal. Now, I want to introduce you to the parties in this case. First of all, we have the plaintiff, Dinesh Ray. I'm going to call him mostly either Dinesh or Mr. Ray, but Dinesh is the plaintiff. He is a gentleman who has tremendous experience running convenience stores. Mr. Ray is the purchaser/investor of the Chevron gas station and convenience store. This is the story about Mr. Ray bringing in his experience as a manager, operator, and even a previous owner of a convenience store, combining with Mr. Khan, who was the owner and operator of defendant in Nahar Investments. And together, the two of them were going to come and run this convenience store. Mr. Ray believed that because he has tremendous experience in the convenience store business, that he was a natural partner to someone who wanted to invest in convenience stores, but did not necessarily want to operate them. If you want someone who knows and understands the convenience store business, Mr. Ray said, I'm the guy. I've done it. It's in my family. I am the guy to run this business. Because of his expertise, Mr. Ray believed he could run the store, he could manage the coin-operated amusement machines or COAM machines, that he had the experience to order the merchandise, to manage the gas supplies, and to be the operations guy of the partnership. Dinesh rightfully believed that he was a perfect person to run this business. And the evidence is going to show that Mr. Khan, the defendant, recognized this fact. Dinesh believed that he would be treated fairly by Mr. Khan. However, the evidence is going to show that is not the case. The evidence is going to show that this business was having problems from the beginning, and that the problems only got worse before they could ever get better. Dinesh did not have a fair chance to run this business given the problems that he had. But Dinesh did not know these problems were even coming on the horizon when he did this deal. He agreed to purchase 49% of the Chevron gas station and convenience store. And of course, 51% would be owned by Mr. Khan still. So think of In Nahar Investments. That is the company that owns the gas station. Mr. Khan owned 100% of In Nahar Investments. Now, just to make this easier, I'm just going to refer to it Nahar. Nahar is a company. So think about Mr. Khan, 100% owner of Nahar. Nahar, 100% owner of the Chevron gas station. So even though we may be saying sometimes Nahar, sometimes I may say the convenience store, sometimes I may say the Chevron, really we're talking about the same thing. The business is the operation of the Chevron gas station and convenience store. The 49% was what Mr. Ray was purchasing. So he was going to become a not quite equal partner. Mr. Khan was going to retain 51% and thus would retain control. The evidence is going to show that Mr. Ray paid $347,733.26 to the defendants. The evidence is going to show that these were a variety of payments, Some went to Mr. Khan, some went to Nahar, and some went to TSTT, the third defendant. Now, the evidence is going to show that they did this deal. Then Mr. Ray went and started operating the business. He was the operations guy, after all. He was the guy who had the experience, and he was the guy who was going to be the store manager or order the merchandise and use his experience to build and grow the business. Now, the evidence is going to show that Dinesh was fired during a difficult time. And we'll talk at length about what those difficult times were and what Mr. Ray was doing to try to recover from those difficult times. However, just as the business was about to turn the corner, that's when Dinesh was fired. So he was not allowed to see the success that he had worked hard to build. He was not allowed to participate in the financial windfall of the revived business. Now, you're going to hear about the investments that Dinesh made. I already said that he paid $347,000 to buy this 49% interest in the business. However, he didn't get any stock certificates. He did not get any membership shares. He never got to see bank accounts. He never got any tax documents. So when the company had a loss, he did not participate in the loss. He wasn't able to deduct that loss on his taxes. When the company had a profit, he did not get a profit share. He never got a single K-1 document. The evidence is going to show he got nothing for the money that he paid. Now let's meet the defendants. We have Mr. Khan, who is here with us today, and he had 100% of the shares of Nahar. So the contracts are going to be sort of complicated because you got the three parties. You got Mr. Khan, Dinesh, and Nahar are all sort of intertwined in these documents. When the witnesses take the witness stand, we will ask them to explain to you what the documents show. The documents will hopefully be admitted into evidence, and that will be a part of the overall case. However, the documents don't tell the whole story because the documents do not show what happened afterwards. Does not show the intent of Mr. Khan when the documents were signed. So Nahar is a limited liability company that owns the Chevron business. And Dinesh bought 49% of Nahar. Now, the payments that he made were to Nahar. The payments that he made, some of them, was to TSTT, which is another defendant. So let's talk about the business itself. So the business is your typical Chevron gas station and convenience store. The business is located at 1131 North Hairston Road, Stone Mountain, Georgia 30083. Dinesh was to be the store manager, the operator of the business, and to run the day-to-day operations, order supplies, hire staff, schedule staff, do all the things that a store manager would be expected to do. Now, as an owner, Mr. Ray expected to participate in the profits that he generated. But even if he didn't generate profits, he should at least participate in the losses that the business generated. I think the evidence will show that there was some good times and some bad times. Now, Dinesh did not receive any ownership rights or stock certificates or shares or anything like that, like we've talked about. And the evidence is going to show that Mr. Khan took the money and gave Mr. Ray nothing. So starting in October 2021, the parties were talking about collaborating on a business. The evidence is going to show that at the time where they started talking about it, Mr. Ray owned his own convenience store. Mr. Khan owned one or more convenience stores himself. That in fact, the Chevron was very close to Mr. Ray's own business. But because of a lease dispute with his landlord, he ended up closing that business. That made him available to do a deal with Mr. Khan. The evidence is going to show that they basically came together as partners. We have Dinesh, who is the operations guy, and Mr. Khan, who's the money guy. You will learn that Mr. Khan controlled the process. He had his attorney draft the documents. He did not really negotiate with Mr. Ray, did not give Mr. Ray a chance to see the contracts until they all showed up for signature at the attorney's office for closing. In fact, the evidence is going to show that Mr. Ray paid $200,000 as part of the closing, earnest money, and cash due at closing, without really knowing the full details of what he was getting himself into. After closing, Dinesh started work. He assumed Mr. Khan was going to be an honorable guy, that he was going to do what they agreed. 51%, 49%, that they were going to be business partners. And if Dinesh worked hard and ran the store the way that he knew he could and be profitable in a way that his experience told him he could, that there would be plenty of money for both of them. Unfortunately, problems arose fairly quickly. It became apparent that the business had issues, that there were some financial issues, that no matter how many times he asked, Dinesh was not given access to the online bank accounts. Dinesh was not given an opportunity to talk to any financial advisors, any accountants, or any bookkeepers for the business. Dinesh had no idea how the business was performing. The evidence is going to show that as early as the closing, that Mr. Khan knew that he needed to open a bank account that Dinesh was on, to give Dinesh access to the bank accounts, to give Dinesh involvement as a partner in the business. Despite that knowledge, in February of 2022, Mr. Khan did not ever add Dinesh to the bank account. He did not ever open another bank account that was jointly titled. The evidence is going to show that these contracts were terribly one-sided, that they required Dinesh to pay a guaranteed profit. I'm going to use that in air quotes because that's what the contract called it, a guaranteed profit of $5,000 a month. Dinesh also had to pay another payment of $5,344 a month. So before there was any profit for the business at all, there was $10,000 in overhead, in addition to having to buy the gas and the merchandise and all the items to go in the store. The evidence is going to show that there were issues with the business and the coin-operated amusement machines, the COAM. We're going to talk at length about COAM when Dinesh takes a witness stand and explains to you what it is, how it operates, and how that impacted the business. Because the defendant did not accurately explain what the profits, loss, revenue of the business were, Dinesh really did not know that there were hidden issues. The evidence is going to show that there was not any due diligence provided, no documents provided to Dinesh regarding previous financial performance of the business. Dinesh remembers an operations guy, so he was more focused on the lease, the COAM contract, supplies, merchandise. He assumed that if he did his job, that he would the finances would take care of themselves. It was not until his repeated requests to be given access to financial information were denied or ignored. That's when it became more and more obvious that there were probably financial issues going on here. Now, Dinesh operated the business diligently, but this could not be sustained because of the issues with the COAM business. Shortly after they started working, the COAM license was suspended. And as a result of that suspension, they lost the license for 12 months. That's when the financial troubles really hit. The parties agreed to suspend the regular payments, and they toughed it out. Dinesh actually worked shifts. He was not only a manager, but he was working shifts at the store. And he was doing everything he could to keep the store alive. The evidence is going to show right before the suspension of the COAM license ended, right before COAM machines, the machines would go back online, that's when he was fired. And it was because of the fact that the COAM machines were about to go online, that's why he was fired. He was not given the opportunity to reap the reward of the 12-month suspension, the hard times that he suffered through. He was not allowed to reap the rewards of when that hard times would come to an end. The evidence is going to show that Mr. Khan kept that money for himself. that Mr. Khan fired Dinesh from the business and since then has basically ignored Mr. Ray. Now, as a true owner, Dinesh should have received 49% of the profits. He should have received a K-1 for his taxes. The evidence is going to show he got nothing. And that's where the problem is. When Mr. Ray was fired, he had paid a total of $347,733.26 to the defendants. And he also paid money to the vendors out of his pocket. The evidence is going to show he paid almost $16,000 out of his pocket. So let's talk about the payments from Dinesh. So first of all, we have the total amount that was paid, which is $347,733.26. So let's show how this money was paid. First of all, we have the first $50,000. Those are the two earnest money checks of $25,000 each. Those checks are written on the name of Bell's Food Mart. Now, Bell's Food Mart is the company that Mr. Ray operated before he went into partnership with Mr. Khan. So you're going to see when we introduce the checks as evidence, you're going to see that they're written on an account called Bell's Food Mart, but they are signed by Mr. Ray. Those checks will go towards the closing. Then after those checks, you're going to see the three checks for the money due at closing. These three checks total $150,000. Remember, I mentioned earlier, he was 200 grand in at closing. So that is $200,000, 50 earnest money, 150 paid at closing. The evidence is going to show all those other checks are payments that Dinesh made to one or more of the defendants. And that totals $131,750. And that are the checks that were paid over time and checks that were paid to the different, Indahar investments. Those payments were in addition to the $200,000 paid at closing. Now, the evidence, when Mr. Ray takes the witness stand, he'll explain to you what all these checks are for and who they went to and why they were written the way that they were written. Suffice to say, for purposes of this conversation, this is a total of payments made to the defendants. So let's go to the final page. In summary, we're asking you to award total damages of $384,904.79. So that's composed of unwinding the deal, which is the payments that were made, $347,733.26. Those are all the payments that Mr. Ray made to the defendants and the payments he wrote, the checks he wrote directly to vendors out of his own pocket. So we're asking for that. Plus, we're asking for attorney's fees of $37,171.53. So the total that we're seeking today is $384,904.79. But you remember how I told you Mr. Khan was a scammer. The evidence is going to show that his actions amounted to fraud. And if you find that his actions did amount to fraud, or that he converted the funds that were entrusted to him by Mr. Ray to his own personal use, then in that case, we're going to come back to you and ask you to make an award of punitive damages. Let me thank you again for your service today and for the help that you're going to give to Mr. Ray to get his justice. Thank you. Okay, go ahead and log out.
Good afternoon. Like Mr. Collins said, appreciate your time. My client, Mr. Khan, on behalf of himself individually and his companies, he's also, very appreciative of the fact that despite everybody's busy schedule, he also gets his day. You heard Mr. Collins refer to my client as a scam multiple times. The evidence is going to show that nothing could be further from the truth. In fact, the evidence is going to show that my client did everything he could to allow Mr. Ray to fulfill the obligations that he agreed to in his contracts. and Mr. Ray was so unsuccessful in fulfilling those obligations, my client had to pay exorbitant amounts of money that were responsible by Mr. Ray in those contracts just to try to keep the business afloat. Slide. As Mr. Collins referred to, at the time of the facts in question, these individuals were dealing with this Chevron gas station business. As Mr. Collins referenced, the arrangement of being a potential partner was such that Mr. Ray, who, as Mr. Collins stated, had all of this experience in the gas station and convenience store business, approached my client to be a partner for this particular station. Now, the good news for you is that you're not going to have to worry about what somebody thinks the deal was, what their impression was, what they think was supposed to happen, but it didn't, because it's all written down in a contract. You're going to see two contracts. One is going to be for the purchase of 49% of my client's business and our LLC. And you are going to see that on February 11th, 2022, my client did in fact agree to allow Mr. Ray to purchase 49% of that company. You're also going to see that simultaneously, because there was going to be this 51%, 49% partnership, that the partners entered into an operating agreement. Now, what you are also going to see is that as part of both that purchase agreement and the operating agreement, Mr. Ray, who admittedly from his own attorney has so much experience and expertise in the gas station and convenience store business, decided to agree to the following. The documents are going to show, number one, that during the time that he is to manage the business, he is responsible for making sure that all of the business overhead is taken care of. You're also going to see that he agreed that in addition to ensuring that all of those bills were paid, that $5,000 a month was paid to his partner, Mr. Khan. You're also going to see in both of those contracts that he agreed to indemnify and hold harmless Mr. Khan even beyond the management period for any claims and losses and liabilities relating to the lease with the landlord, the fuel supply contract with Chevron, and with the coin-operated amusement machine agreement. You're also going to see that the contract clearly states that in the event Mr. Ray failed to meet those obligations for that management period time, that Mr. Khan had the right to expel him as a manager and reclaim the management position for himself. Now, you are going to see that both of these contracts specifically say the initial management period was going to run from February 11th, 2022 until January 31st, 2024. As I've already alluded to, the contracts are going to say that Mr. Khan had a right to shorten that management period time in the event that Mr. Ray failed to meet his contractual obligations. Now, that contract also states that in the event that the business had any net profit beyond those bills being paid and the $5,000 being paid to Mr. Khan every month, Mr. Ray would keep all of the rest of the net profits. Now, you are going to see from the evidence that neither Mr. Khan nor Nahar LLC breached any of the agreements. You're also going to see that there was no fraud that was committed on the part of Mr. Khan or Nahar LLC. In fact, you are going to see multiple references within these contracts to the fact that the parties are not relying on any promises, guarantees, or anything of the like, other than what is in that contract. Slide. We've already gone over the principal terms that Mr. Ray agreed to under these contracts. These bullet points reiterate those principal terms. Now, I want to be clear. Not only did Mr. Khan agree to allow Mr. Ray to be the manager and collect all the net profits after those liabilities were covered, the purchase price to own 49% of this company was $263,170. He still hasn't paid that. He's only paid a fraction of that. So there is a deficiency not only with the purchase price, but there is a large deficiency in all of the bills and overhead expenses that Mr. Ray was responsible for that my client ended up having to pay. Furthermore, you're going to see that there is a deficiency with respect to the $5,000 monthly payments that Mr. Ray was to make to Mr. Khan. And you are going to see plainly spelled out in the contract that at the end of the management period, whether it be the entire period, again, January 31st, 2024, or any time beforehand, which in this case, it was cut short prematurely to November 11, 2023, that the inventory shortfall for the store would be the responsibility of Mr. Ray. Conversely, if the inventory was higher than what it was when the management period began, he would be owed this. So you're gonna see a deficiency on the purchase price, the bills that he was responsible for paying that my client ended up paying, the $5,000 monthly payments, and the inventory shortfall. Slide. As I alluded to earlier, there is nothing that transpired between these individuals that was fraudulent. Just as my client had every opportunity to contemplate and explore the notion of selling 49% of his company to Mr. Ray, Mr. Ray likewise had every opportunity, again, as an expert in the gas station and convenience store industry, having all this experience, in fact, having a gas station across the street from the Chevron at issue, had every opportunity to demand any additional due diligence time in the agreement, to consult with as many lawyers as he wanted to before he entered into the agreement. And there is nothing that transpired after that or before that could possibly be construed as a fraud. When we were doing our voir dire, several of the prospective jurors mentioned that they had attempted various business ventures, and all but one has been unsuccessful. We all know that entering into a business can be a risky proposition. Sometimes we win, sometimes we lose. And in this case, the reality is he agreed to what he agreed to. The contracts speak for themselves. If the business wasn't profitable, it's not only not profitable for Mr. Ray, it's not profitable for Mr. Khan. And the evidence is going to show that this entire notion that Mr. Ray was let go as a manager just as the business was about to turn around, well, this business has operated at a net loss since February 11, 2022. So, like I said, the evidence is going to show that not only did Mr. Khan pay exorbitant amounts of money that was the responsibility of Mr. Ray under the company just to keep the business afloat, it is still to this day barely hanging on. So if there's anybody that went above and beyond to ensure that this business would be a successful venture, it sure wasn't Mr. Ray, it was Mr. Khan. And like I said before, the notion of Mr. Ray being expelled as a manager is clearly within Mr. Khan's rights as outlined in the contract. Slide. Like I said before, Mr. Ray freely entered into the agreements. And you've heard his attorney talk about how much experience he has in the gas station and convenience store industry. So he knew full well what his opportunity, risks, and benefits were. The obligations of Mr. Ray could not be more clearly defined in both the purchase agreement for the 49% and the operating agreement between the partners. You are going to see without question that Mr. Ray did not comply with those obligations. Yes, the business was not successful. The business was losing money, but that does not change the fact that the evidence is going to show that it was his responsibility if he wanted to have that management position and potentially reap all of that net profit after that overhead was taken care of, to be responsible for those bills. As I continue to state, and as you're going to hear at the conclusion of this trial, my client and Nahar did not commit any fraudulent activity. Everybody went into this deal eyes wide open, and everybody knew what was happening with the business. Nobody better than Mr. Ray, because he was the one in the store managing it every day. So this entire notion that he was in the dark on the finances is a paradox. He was the manager between February 11th, 2022 and November 11th, 2023. As Mr. Collins correctly noted, my client wasn't running the store. So it's a paradox again to say that he was in the dark about the finances of the company when he's running the company every day. Now, this is something I want to hammer home. There have been, as you can imagine, various documents, statements, responses that we have gathered throughout the course of this case from Mr. Ray. And the evidence is going to show that these claims are inconsistent, they're incompatible. The statements are contradictory and inconsistent. And at best, going into this trial, one could only assume that he just thinks he should get his money back. That's it. A business went bad, he's upset about it, and he wants his money back. Well, my client wants his money back too. Money that he agreed to pay. Now, you heard Mr. Collins say in his opening that conclusively what he wants is to unwind the deal. Because the business operations were so poor, the only thing that is suitable is to unwind the deal. And therefore, everything that he paid should just go back to him. Well, you are going to see multiple claims and statements and positions asserted by the plaintiff that completely contradict that that's what he wants. Sorry. Now, if he is claiming that what he wants is to undo the deal, to rescind the deal, to go back to where the parties were before February 11th, 2022. Please, number one, listen closely to what the documents and the witnesses say. Please pay particular attention to the timeline of events that transpired between February 11th, 2022 and November 11th, 2023, which is when the management period was cut short, to what you are going to see for the first time ever, a demand from Mr. Ray in May of 2024, all the way to the lawsuit that was filed in June of last year. And then try to comprehend the notion of, quote, unwinding the deal. Now, as the judge pointed out as part of his introductory remarks, I would also like you to just please bear in mind, yes, Mr. Ray, in the style of this case, is denoted as the plaintiff. As you will see, in his lawsuit, he claimed 3 substantive causes of action: breach of contract, fraud, and conversion. Please bear in mind that he's carrying that burden of proof for those causes of action. And that for my clients, Muhammad Khan and Nahar Investment, for its one and only substantive counterclaim, which is breach of contract, breaching the purchase agreement, breaching the operating agreement, we carry that burden for the damages that we're seeking in regard to that counterclaim. Now, I also, again, I said I was going to hammer it home, and I am. Although his lawsuit has 3 substantive claims: breach of contract, fraud, and conversion, you heard Mr. Collins in his opening say what they're asking for is to unwind the deal, put the parties back to where they were in the beginning, to rescind that deal. These, at the conclusion of the closing arguments between counsel, paid careful attention to the judge's instructions on what the law is for those claims. And after you go back and deliberate, this is what we're asking you to conclude. We're asking you to reach a verdict in favor of the defendants as to plaintiff's claims: breach of contract, fraud, and conversion. Obviously, when that occurs, those ancillary claims for legal fees and punitive damages will necessarily die off. However, as to our counterclaim, we are going to show you, simply based on the purchase agreement and the operating agreement, that a principal amount of $338,378.85 is still owed to Mr. Khan and Nahar LLC. We know this because $5,000 was short for cash at the closing. We also know that part of this purchase price, if you'll recall, was $263,107 was part of a promissory note. The promissory note was $63,107. That remains totally delinquent, despite the fact that he had been managing the store for over a year. You're going to see that for the 21 months that Mr. Ray was a manager, where he owed Mr. Khan $5,000 a month, he's short $80,000. And you're also going to see that all of the liabilities, all of the overhead costs, all of the bills, fines, anything that is specified in the purchase agreement and operating agreement in terms of liabilities that Mr. Ray is responsible for, there is a total of $128,292.50 that my clients ended up having to pay because he didn't. And it was the only way to keep that business running. And as I mentioned earlier, when the plaintiff was expelled as a manager of the company, there was an inventory shortfall of $61,979.35. At no time has my client ever asserted or took the position that Mr. Ray does not own 49% of that company. You're never gonna see a piece of paper representing that. In fact, you're only gonna see and hear testimony that shows he is a 49% owner. The problem is, as I mentioned earlier, you're going to hear testimony that plainly establishes that owning 49% of N-Nahar LLC since 2022, meaning you own 49% of a negative number. So all of this insinuation that there's this jackpot of money that somehow Mr. Ray is supposed to be owed because he is a 49% owner of the company is just smoke and mirrors. There's nothing out there that represents this small fortune waiting in the wings. As I mentioned earlier, we know from February 22 to November 2023 who is running the business. And we know that the business, by Mr. Collins' own admission in his opening, was not making any money. So there's no money to be had there. And between November 11, 2023, all through the taxable year of 2024, there's not going to be any pot of gold there either. So basically what you are going to be left with is a case where Mr. Ray had the temerity, knowing that he failed to fulfill all of these plainly spelled out conditions in contracts that he, as an expert in the gas station and convenience store industry, agreed to sign. He failed to pay my clients all of this money, and yet has the audacity to say, well, not only is this irrelevant, I should get all the money back that I paid for this business as well. And mind you, when the slide was up during the plaintiff's opening, and there were two columns, one of those columns was literally bills that were paid by Mr. Ray during the management period. Well, I can't emphasize this enough. Both the purchase agreement and operating agreement say, when you are the manager, you have to pay all of the bills. You get any net profit after all of the bills are paid, and $5,000 a month is paid to Mr. Khan. So it's even more audacious to claim that he should be getting back the money that he put into the business that the contracts specifically say he's supposed to put into the business. Now, lastly, we too have an ancillary counterclaim for attorney's fees and litigation expenses. Meaning, we believe that the evidence is going to clearly establish that the fact we had to defend this lawsuit and actually go to court for that sum of money could not more clearly represent a stubbornness, an appetite for litigiousness that would, and just complete undue trouble and unnecessary expense for Mr. Khan and N-Nahar, that you should come back from that deliberation and award our attorney fees and litigation expenses associated with having to deal with this case. Now, as of this morning, the sum that we were seeking was roughly $9,000 less than plaintiff's counsel. It was about $27,500. Now, obviously, you see attorneys here at the table. We're here for this trial. And when we do our closing, we will have that final number for your review when we necessarily have to tack on the legal fees and the court costs associated with defending this action as part of this trial. So I just want to make clear that you're really not going to have to worry too much about what anybody says happened, what they think was supposed to happen, what they were hoping was going to happen. As the judge mentioned in his opening remarks, it's a contract case. And the good news is you're going to have the contract. You can literally see without any confusion what Mr. Ray agreed to do. And after hearing from Mr. Khan, you're going to be able to clearly outline all of the monies that he still owes. Again, I thank you for your patience. I thank you for your time. And again, we all know how busy everybody's schedule is, but we're glad that we have this opportunity to finally put some closure on this case. Thank you.
All right, and so opening statements having concluded, members of the jury, we would now begin with the plaintiff's opportunity to present evidence. And so is the plaintiff ready to proceed?
Yes, Your Honor.
All right, you may call your first witness.
We call Mr. Khan for purposes of cross-examination.
All the way up to that seat. It's the far seat, right?
There should only
Yes,
be one
okay.
down there. All right.
Hi, my name is
Oh, just a second, sir. Just have a seat. And we're gonna swear you in first.
Where's that? That's that. Yeah.
Testimony in the matter of this case is the truth and nothing but the truth to help you.
Yes,
Would you please state your name and spell
Okay.
your name to the court? Speak into the mic.
my name is Mohammed Tuin Khan,
If you could spell that for a court reporter.
Mohammad. Middle name is Tuhin, Tuhin. Last name is Khan, Khan.
Your
All
Honor,
right,
may
now so
I
you can
please-
proceed.
May I approach the witness with the one trial
Come here.
notebook?
Put that second.
And please state your name for the record.
Well, he's done that.
Pardon me?
He already did that. and he
Okay.
spelled it.
So I want you to look at Exhibit 1. That's on the first page of the first tab of the trial notebook. Do you have that in front of you? You see that?
Yeah.
Okay. And what is the title of this document?
This is the agreement for the NR investment and Mr. Dinesh Rai.
And in fact, the title of Exhibit 1 is Settlement Statement of the Purchase and Sale of 49% Ownership Interest. Is that correct?
Yes, he's interested for 49%, yeah.
Okay. And the date of this document is February 11th, 2022, right?
Yes,
And the seller is listed as you, correct?
this is NR investment LLC.
Well, it says here seller Mohammed T. Khan,
Yes,
right? Okay. And it says buyer Dinesh Thuling Ray, correct?
yes,
And the purchase price is listed as $263,107. Is that correct?
which one? Is for
Purchase
the,
price.
yes,
Okay. Can you look at this document real quick and make sure this is a true and accurate copy of the
Which one?
purchase? The purchase agreement?
yeah,
Is this an accurate copy?
yes, this is the copy.
Can we just stipulate that the
Mhm.
contracts are?
Yeah.
All right.
Now would like to tender Exhibit 1 into evidence.
Any objection?
No, sir.
Exhibit 1 is admitted.
All right. And so if you look at that page 1, it shows the total paid of $263,107. You see that there?
Yes,
And that is composed of the $50,000 earnest money paid, right?
yes, it's $50,000 honest money paid.
You in fact did receive that $50,000 from Mr. Ray, didn't you?
Yes,
In fact, you received 2 checks of $25,000 each as the earnest money, right?
I am not remember this 25,000 or more, 2 check or 1 check. I am not remember that, but $50,000.
It was paid. The 50,000 was paid.
Yeah,
Okay. And then you did receive the $150,000 cash at closing, right?
basically he give me the $5,000 check. This honest money is together, but he say is not to deposit. I have still his check my pocket.
So, Your Honor, I would ask
His
that.
this one is $45,000. His total closing time he paid is $145,000.
All right.
Your Honor, I would ask that you instruct the witness to answer the question, then he can explain the answer. So I'm asking yes or no questions, then he can explain.
Understood. And we're going to be dealing with a few communication issues, so we'll work through those. But generally, sir, you have the opportunity to explain your answer, but let's start with a yes or no answer. If
Oh, that I
Right.
the yes or not, I am not get the $150,000.
Okay,
I get $145,000.
okay. And then there was a promissory note of $63,107.
Yes.
Okay. And if you turn to the next page, you look at the bottom of each page, it's got a number on there. So we're going to page 2. This document is entitled the Agreement for the Purchase and Sale of 49% Ownership of Nahar Investments, Inc., LLC. Is that correct?
Yes.
And this is actually signed on February 11th, 2022, isn't it?
February 11, 2000. Yeah.
Okay. And then it says that this is for the sale of 49% membership interest in Nahar Investment LLC, right?
Yeah.
So at the time that this was entered into, you were 100% owner of Nahar Investments, weren't you?
This time I am the this time I am the 100% owner, but I sell the 49% Mr. Dinesh Rai.
Okay. And then it says, if you look, scroll down just a little bit, it says the company is currently the tenant under that certain lease agreement initially entered into with AMA Investment, Inc. So you were Nahar was a subtenant, is that correct?
Yeah. So no subtenant. This is when is the previous basically this lease is doing the another company. He sell to me, and this I am in the right now. I am the get the lease signed from the landlord. This means I am directly right now. I am the owner for the. I am not a sublease, but I am right now. I am in the direct lease. Because it's landlord signed to us. She assigned this. I am the lease purchases right now.
Okay. And is AMA still involved in this, in the property?
Yeah, he's a landlord.
Okay. So he is the landlord. and
Yeah.
You have a lease directly with AMA.
Yeah.
Right?
Yeah, I get the lease directly from the MAA.
Okay. Do you still have if you look at the next paragraph, do you still have the lease with AGM Ventures LLC?
AGM, I don't know the AGM. What do you mean AGM?
So it says, whereas the company and or seller entered into that certain bona fide coin operated amusement machine lease agreement with AGM Ventures.
No AGM vendor right now. This is another company.
Okay. So you changed out from AGM?
No, I am not a changer because I cannot change myself. My landlord have to assign. Then I am do the another company or not. It's not a directly. I cannot do anything.
Okay. So at the time this agreement was entered into, was AGM the coin op
Yeah.
company that you did business with? Need you to answer the question, please.
Yeah, this this company is operating the this company for the master license is lottery.
Okay. So it was AGM and you're saying your testimony is that that's changed.
How do you mean test money? I don't understand.
So when you signed the agreement, AGM was a COAM provider,
Yeah.
right?
Yeah.
And then you're saying at some point that changed?
No, we are not changing.
Okay. So you're still with AGM.
I am still is the previous company.
Okay. If you go to the next page, page 3, this lists the purchase price. Do you see that? 263,107. We saw that from a little bit higher up. 263,107. That was from the first page. Remember the settlement page?
Yeah.
Nope. Or scroll down. There we go. And so that again lists the earnest money and the and the promissory note. So now we go to the next page. I want to talk to you about the purchase price. How do we get to that purchase price? So the first line item, it says $30,000 security deposit paid to jobber under the gas supply agreement.
Yes,
That's a deposit you paid, right?
yeah.
And did you pay, that is the total amount, not half of the amount.
No, total amount I need
Total
to pay
amount?
it. Yeah.
Right. And then it says value of inventory. How did you know that the inventory was valued at 104,911.76?
This, you have a inventory guys, they're coming and they're do the physical inventory. This time, I am and Mr. Dinesh Rai is together is present. And we have a both party signature in the inventory report.
So who did the inventory? You said the inventory guy.
Yeah, Mr. Dinesh Rai hired this inventory guy.
So he hired an inventory
Yeah.
guy. At the very beginning, he hired an inventory guy.
Yeah,
Okay. And so that inventory is showing as 104,911.76.
yes.
Okay. And so then it says $400,000 goodwill of business. How did you come up with that number?
Because you have a market value and Mr. Dinesh Rai is coming a lot of time in my store because he's do the cross street. Before he's working over there, he coming a lot of times, maybe month to month, coming the store, stay here. I am not there. This time he be there too because I am not all the time in the store. Mr. Dinesh Rai coming over there and he's looking for the sale and everything. Then we guys both decide the purchase price.
So,
We are together. It decide the purchase price.
but how did you come up with the 400,000? Did you hire an appraiser?
Because it's,
Objection asked and answered.
I think we still need to flush this out. Overruled.
Did you hire a private appraiser?
basically we are not before I try to sell the business. This time somebody offered me $4,000, 400K. Okay, then this time I am not selling. Okay, somebody's offer, and I told Mr. Dinesh this somebody offered me 400K. He agreed to buy 400K. Then we decide the price.
So in fact, you offered to sell the business to Mr. Ray, didn't you?
I am not offer. He's coming. I am not offer Mr. Dinesh.
Okay, you did
Because
not.
I am not going his store over there. Close street the store, but I am not go his store. He's all the time coming our store.
Okay. And then this sentence right here says, seller has the right to withhold all closing documents, including operating agreement, signed at closing, and in the event of any of the checks fails to be honored by the financial institution, seller shall have the right to void the transaction and seek all damages from buyer. First of all, well, I mean, that says that, correct?
Yeah,
Okay. Were any checks paid by Mr. Ray ever dishonored?
yeah.
He wrote you a check. that was-
He write the check, not this check, but he write the check, the business check, do the vendor or somewhere, his lot of check is dishonored.
He wrote no checks to you that were
No,
dishonored.
no.
Okay. And then, did you in fact hold on to the closing documents?
Because when we do the closing, he take the documents too, right? So why he take the documents?
The lawyer.
When we do the signing the documents, he should be take the documents from the lawyer because both parties there, right? He should be take the documents from them.
But the lawyer worked for you, right?
Yeah, lawyer is both party working for the lawyer. It's not myself. We are we are going to the lawyer. They do the signing, and both parties there. They do the signing. I am do the signing. I take my documents. That's it.
But Mr. Ray didn't get a copy of the documents.
I don't know. I don't know this part.
Okay. But the attorney that you went to for the closing, he was your attorney, wasn't he?
But he should be take the documents from them, not me, right? Because lawyer have two documents. He should be take his signature. He should be take the documents. He cannot tell me this after 20 on month. He cannot tell me this part.
To your knowledge, Isn't it true that Mr. Ray never?
I don't
called-
know.
Let me
I-
finish. Never talked to the lawyer prior to the closing?
I don't know because he have a lawyer phone number too. I don't know this part.
Okay. To your knowledge, did Mr. Ray ever get a copy of this purchase and sale agreement?
I don't know.
Okay.
I'm not remember that.
Let's look at page 7. So on 7, paragraph 18D, so near the bottom of the page, it says repossession of business and business premises. In the event buyer is in breach of the loan documents and fails to cure within 30 days after the delivery of notice by seller, in addition to other rights and remedies provided in this agreement, operating agreement, and/or loan documents, seller shall have the right to take possession of the business and business premises immediately. Did you ever exercise that right?
Yeah, I am try, but he request to me, he run the store, he collect the money, and also this, he, whatever I owe the money, he paid it. Always he tell them this way. Okay. He said this, I believe him, because I believe him, that's reason I give him the store. But you have a promissory note is due, we have inventory, is due, he don't pay my $5,000 every month. I believe him. That's reason last I talked to him and we talked together and I said this, pay my money, whatever I owe money, paid it and run as like you are a manager. I told him, when is my last meet? I told him this part. Whatever I owe the money, paid it and run as like your manager before whatever you have. But he said this, okay, that's reason I am not send any notice or any letter for give me my money, give me whatever I owe the money, paid it.
Okay.
If I know he send the letter from you guys, then I send the letter from my lawyer that whatever I owe the money, paid it, please. That's the reason I am waiting. But when I am waiting couple of months and
All right,
he
so-
sent
so
the letter.
We're getting a little further afield of the question. Let's focus on the
Okay,
questions
sure.
that are asked. All right, counsel.
Okay, let's go to page 8. Under F subsection 1, it provides the term of the purchase and sale agreement, and the management period is defined as from the date of the contract through January 31st, 2024. Was that correct? Is that what you expected the management term to be?
Yeah,
Okay. And then if you go to subsection II, the next paragraph, that provides for the $5,000 monthly guaranteed profit, correct?
yes.
Is it true that you never discussed that monthly guaranteed profit with Mr. Ray?
No, I am not discard about that. Whatever have the agreement, I am always follow the agreement.
You did. So did you discuss it with Mr. Ray?
No,
Okay. Isn't it true that the convenience store was not profitable prior to this business, to this agreement being signed?
no, this is a profitable business. This is not a non-profitable business. When I am run it, it's profitable.
So you said when you ran it,
Yeah,
when did you run it?
I am run 2019 and before is the February 2022. This time I am run the business. This time is profitable business is in our investment.
So when did you personally run the business?
2019 to 2022.
Okay. If you would go to page 9, that is a copy of your signature. Is that correct?
Yes.
Let's go to Exhibit 2. Exhibit 2 is entitled The Assignment and Transfer of Interest in a Limited Liability Company. Your Honor would like to tender Exhibit 2 into evidence?
Any objection?
Oh, I'm sorry. One moment. I'm not showing that. I'm showing exhibit 2 is the operating agreement. Yeah, I'm showing it's the operating agreement.
You want, I got a notebook for you if you want.
I'll just use this one. It's fine.
Okay,
No objection, Judge.
All right, Exhibit 2 is submitted.
okay. If you look at Exhibit 2, this is also dated February 11th, 2022. Is that correct?
Which one?
Exhibit 2 is on page 11,
I don't-
tab 2.
It don't have any pages there.
It's very bottom has the numbers, and then the tabs, of course.
Yeah, is last is 10 here.
You see that document on the screen?
Oh, yeah,
Okay, so this is dated February 11th, 2022, right?
yeah,
And it shows you as the person transferring 49% to Mr. Ray, right?
yes,
And in fact, it says you are transferring 49% membership interest in and to Nahar Investment LLC. Is that right?
yes,
And so at the end, Mr. Ray has 49% and you have 51%, correct?
yes.
Okay. Is that in fact your signature at the bottom of that page?
Yes,
Okay. Let's go to Exhibit 3. Exhibit 3 is a copy of the promissory note. Your Honor would like to tender Exhibit 3 into evidence.
Any objection?
No, sir.
Admitted.
And this is also dated February 11th, 2022, correct?
yes,
And this is titled promissory note, right?
yes,
Okay. And the total dollar amount is $63,107.
yes,
If you look at the second paragraph of this document, this calls for payments to be made in 12 consecutive monthly payments, right?
yes,
And in fact, those 12 payments are $5,344.77 per month.
yes.
These are payments that Mr. Ray had to make to you for the purchase. Right.
No, he don't make this any check or something. He don't pay it this amount.
Was this payable to you or to Nahar?
It's payable to me.
Okay. And this was going to be, the first payment, it says, is due on February 10th, 2022, right?
Yeah,
And that it would be 12 payments, right?
yes,
It also says there in the third paragraph that the interest rate was 3%, right?
yes,
So 12 payments equals $5,344.77, right?
yes,
Okay. So it says, in the event of default, holder shall notify maker in writing of such default, and maker shall have 5 days from the receipt of said notice to cure default. Isn't it true that you've never provided any notice of default?
I talked to him couple of times. He said this. I arranged the money and I provide you the check, but he never did it.
Okay. So you talked to him like on the telephone or in person?
It's person and telephone too.
Okay. Let's go to Exhibit 4. This is on page 15. This is a copy of the security agreement. Judge would like to tender Exhibit 4 into evidence.
Any objection?
No, sir.
Admitted.
Okay, so Exhibit 4 is called the security agreement. And this is for the loan between Mr. Ray to you. This is related to the promissory note, right?
Yes,
Okay. But it also mentions that there was an SBA loan. Was there an SBA loan at the time?
no, this time is before his SBA loan. This is not he's not included in this promissory note also. This loan is before COVID time. This time I get this loan.
Okay, but it's referenced here. So the SBA loan was in existence at this time?
Yeah, this time have this loan, but this is not including the Mr. Roy.
Okay.
This is my
Were you expecting Mr. Ray to pay this SBA loan?
no,
Okay.
never.
Let's go to Exhibit 5. This is called the Pledge Agreement. Your Honor would like to tender Exhibit 5 into evidence?
No objection.
Admitted.
Thank you. This is on page 18. So this is also dated February 11th, 2022, right?
Yes,
And this is also in support of the promissory note, correct? Right?
yes,
Okay. So if you look on the second page of the note, which is page 19, talks about distributions. The first sentence says, unless and until an event of default as herein defined occurs hereunder, pledgor shall be entitled to receive and retain any cash distributions declared and paid on the collateral. You see that?
mm-hmm.
In fact, isn't it true that Mr. Ray never got any cash distributions from the company?
After February 11, 2022, and also this November 11, 2023, all cash handling is doing Mr. Ray. I don't know how much is profit and how much is anything. I cannot I cannot handling any cash or something. Basically, I think I am going to the store minimum highly 1 month, 2 month on time. Whatever is time is I am going over there, I can stop by just to look at it. That's it. I am not handling whatever is profit, whatever is everything is Dinesh Rai is know that. I don't know anything.
Did Nahar Investment ever file tax returns?
Yeah, every year they are doing the tax return, and he knows that how much is profit and how much is everything.
But
He
is it
knows.
true, is it true that Mr. Ray never got a K-1?
He don't asking. He's not asking this how much is a profit and how much is loss. That's it. But he don't ask to give me the tax return or anything. He don't ask me that this part.
But you never issued to him a K-1, did you?
No, we do the every year is tax return, and he know this how much is profit, how much is loss is tax return, because I am not handling the cash. That I don't know that too much. I know only for the this time is the do the tax return. I know the how is the profit and how is the loss. That's it. I don't know anything.
Let's go to Exhibit 6. Exhibit 6 is the operating agreements on page 24. Your Honor would like to tender Exhibit 6 into evidence.
No objection.
Admitted.
So Exhibit 6 is the operating agreement. All of these contracts to date were all drafted by the same attorney, right?
Yes.
Including the operating agreement.
Yeah.
And this is also dated February 11th, 2022. Right?
Yes.
What was the name of the attorney who drafted the
It's
agreement?
Shupuchan. Shupuchan.
Can you spell that for the court reporter?
I cannot explain to correctly because I don't have his card or something.
Okay.
I
His
can do
name
it.
is Supuchan.
It's SIUPOCHAN.
Thank you. So if you look at the, let's go to page 29 of the operating, of the exhibit number 6. If you look at section 7.1, it says distribution of cash. Provides a company shall distribute to the members from time to time all cash, regardless of source thereof, of the company which is not required for the operation or the reasonable working capital requirements of the company. Such cash is sometimes referred to herein as cash flow. Isn't it true that Mr. Ray never got a distribution of cash from Nahar Investment?
He do the world cash handling. He doing that. I don't know anything because I am not going to the store.
And then section 8.2 says net profits and net losses of the company shall be allocated to the members in the same proportion they share in distribution of cash flow pursuant to section 7.1, right?
Yeah,
But isn't it true that no distributions were given in proportionate amount to Mr. Ray, right?
I don't understand.
Okay, so this says each member shall take the same proportion of cash flow that they have in their membership allocation. In other words, Mr. Ray owns 49%, so he would get 49% of the cash flow, right?
No.
Okay, but that's what it says, right?
This is I think this is talking about the when is his managing period is done, then after, then after the time, who is the run the store, and we can decide it who run the store management doing that. This time talking about the debt. This is not a this is only for the his managing time, his responsibility, everything, and he pay the me $5,000 every month. This is a talking about, but this is a management is done. Is again is management doing that? This time talking about that.
This says each person shall be allocated to the members in the same proportion that they share in distributions of the cash flow. So if you own 51%, you get 51% of the cash flow. Isn't that what that says?
This is a different management time is done. Then this agreement is coming. When his management period is done with Mr. Rai, then is the coming this agreement.
There is no agreement that is called a management agreement, though.
Yeah.
There is not one, right?
Now this is a different, because we do the management agreement already. When his management period is done, then they are talking about that, Article 7.
So if you look at page 34, if you would, section 14.1, this addresses the management period. It says, commencing from the date hereof and through January 31st, 2024, Dinesh Manthuling Ray, the operator, shall have the right and obligation to serve as the operator of the business, as defined hereunder, and be solely responsible for the day-to-day operation of the business, perform all management duties as defined herein, satisfying all claims, obligations, and liabilities arising from the operation of the business of the company. That is what that says, right?
Yes.
And that Mr. Ray knew going in that he was going to be the store manager, and that's the authority that's conferred upon him, right?
This is when is the agreement say this February 11, 2022 to this 2024. This time he is the managing the store. This time talking about this agreement.
The management agreement.
Yeah.
This is the management agreement right here,
Yeah.
right? And in fact, he is responsible for the lease, the COAM lease, and running the business with jobbers, petroleum products. All of this says, we're on the next page. And upon expiration of the management period, Mohammed T. Khan shall have the right to take over the business and manage its day-to-day operations.
Yes.
Okay. And then it provides a whole list of management duties that are Mr. Ray's responsibilities as the manager, right?
Yeah, because on time is gas lease is coming 10 years. Now, this time it's not coming is not a finish. The gas agreement is not a finish yet. Lease, landlord lease is already done. He don't need to take care of the landlord lease.
Now, Mr. Ray never saw this list
Which lease?
prior to going into the lawyer's office to sign the documents, did he?
Which document you're talking about?
Talking about the operating agreement here on page 12.
Yeah, here, of course he have. Because this is not my, this is when I do the signing, I take my paper. I don't know what did that. I don't know anything.
Well,
But if you have any problem, he can talk to the before, he don't send the letter me or anything. He don't send anything. Then he don't get the lease or he don't get the anything. He need when we do the sign together, he should be get the lease, right?
so you gave him a copy of the lease, right?
Why how I can give him the lease? I take my lease, my copy.
And you showed it to Mr. Ray.
Sorry?
You showed Mr. Ray a copy of the lease, right?
How I can, when we do the signing, he should be, I'm not remember that.
Did you show him a copy of the lease?
I don't know, he's get the lease, when he sign it, he should be, see the lease and he sign it, right?
Okay,
I'm not, I forgot this part, I am sorry.
all right. Did you show Mr. Ray a copy of the COAM contract, the COAM lease?
Coim lease is posted in the office, a store. He should be, see that. Because we need to post the Coim lease in the store. Because it's Georgia Lottery going over there, they look at it.
The license.
Yeah, license and lease, both we need to show.
Okay. And so therefore, there's no dispute that Mr. Ray did see the COAM agreement.
Of course, this store have a lease because this he run this store is 21 month. This time maybe 2-3 times is Georgia people is going, lottery people is going to the store, and he need to show this is the lease, this is the agreement.
Yeah. So let's go to the top of the next page. We're on page 36. It says here that this is section 14.3, and I'm sorry, it's a little bit hard to read. It says Dinesh Manthuling Ray acknowledges and agrees that he shall be solely responsible for any net loss of the business and be responsible for the satisfaction of all liabilities and guaranteed profits to Mr. Khan. Did you discuss that provision with Mr. Ray prior to signing the contract?
Of course, he signed the contract.
Did you discuss it with him?
Yeah,
When?
when we go to the lease office, before we do the talking about that, and we going to the law office, and we tell them the lawyer this, our condition, okay, and he write it, and then he read it and he sign it.
You told the lawyer what to
No,
put
no,
there.
no. We are going together. I am not going myself.
You went there to sign together.
No, no, no. When we talk to the lawyer, we go first time, we both, and second time, we go to the sign. We go 2 times. One time, we go to the lawyer with Dinesh and me. Then we talk to them, he writing, and second, I don't know, 2, 3 or 4 days later, and we go to the over there and we signing the paper.
So is it your testimony that Mr. Ray knew about this onerous provision prior to signing this? document?
Objection, argumentative.
Okay. I'll withdraw the question. So if you go to page 39, the bottom of the page, under outstanding liabilities of the company, it says Muhammad T. Khan agrees to be personally and solely responsible for all outstanding liabilities of the company that accrued or arisen prior to the date hereof, including the SBA loan. Is that correct?
Yes.
Okay, so these says accrued or arisen prior to the date hereof is prior to the date of this agreement, right?
Yes, I am responsible for this money.
So let's go to Exhibit 7. This is a copy of the amortization schedule. Would like to tender Exhibit 7 into evidence.
No objection, Judge.
Admitted.
Did you create this document,
Sorry,
this amortization table, or did the attorney do that?
attorney did that. I am
Okay.
not doing anything.
And this shows the dollar amount of the promissory note and the 3% interest calculated over 12 months, correct?
Yes.
Okay. And that's how the number $5,344.77 is derived.
Yes.
And then the second page, page 44 shows the actual monthly payments, right?
Yes.
Let's go to Exhibit 8. This is a copy of the checks that were provided to us by you during discovery. I'd like to tender Exhibit 8 into evidence.
No objection, Judge.
Admitted.
Okay. These documents, these checks were written on the account owned by Bell's Food Mart LLC. Is that right?
Yes.
And you see the signature, to your knowledge, is that Dinesh's signature?
Yes.
The first check is for $45,000, right?
Yes.
The second check is for $50,000,
Yes.
and the third check is for $55,000, right?
Yes.
And that is the total of the cash due at closing, right?
Yeah, this he give this check for the closing date, but he said this deposit is the, I think is a different date, not the same date.
Right. They're dated different days. That's
Yeah.
correct. But this is the cash for closing in addition to the earnest money.
Honest money, yeah.
Okay. The earnest money we already talked about. So let's go to Exhibit 9. This is also a document that you provided during discovery.
This is a roughly
He was still talking.
We'd
sorry.
like to tender Exhibit 9 into evidence.
No objection.
All right, B9's admitted.
Okay. You tell the court what this is.
This is a roughly I doing that and I provide to the Mr. Justin. Just roughly I do that. This is not actual.
Okay. So this was not done at the time the payments were made.
No,
Okay.
this is not actual.
So next, I want to show you Exhibit 10. Tell us, who is TSTT Development Company LLC?
This is my another company.
This is your other company?
Yeah.
What does this company do?
This is this company. I open it and I try to do the development for the land.
Okay. And what is its connection to the Chevron business?
This is not this is my company. This my company because it's before it's check is my name. This Nahar. That's reason I deposit this check is this TSTT.
Okay. Now, Mr. Ray paid $85,000 to TSTT, correct?
I am not remember, but he's 85,000, 40, and maybe
Okay.
I am not 100% sure.
And he paid that because you asked him to make that
Yeah.
payment. Okay. Then the next page is the corporate record for Nahar Investment. And that's the company that owns the Chevron station,
Yes.
right? And the next two pages are the articles of organization for Nahar,
Yes.
right? It shows you as the organizer for this
Yes.
company. Your Honor, we'd like to tender Exhibit 10 into evidence.
No objection.
10's admitted.
So Exhibit 11, I wanted to ask you, who is SE and She Group LLC?
This is my attorney. Oh, sorry. This is my accountant.
Your accountant?
Yeah.
Okay. So you don't have.
No, no. She and his group LLC. What is that? This is a previous leaseholder. Is from the landlord. I'm sorry.
Okay.
This is a previous leaseholder. I purchased from this company.
So were you a subtenant?
I am not
this?
right now. I am not a subtenant. I am in the direct lease from the landlord. Right now, I am direct lease from the landlord. But this one, I carry the lease from this previous whatever is lease and agreement have. But I am carry this one. But I am give the lease from the direct landlord.
Okay. Let's go to the next page. This is on page 52. This is Exhibit 12. This is another handwritten document that we received. Can you, let's introduce Exhibit 12 into evidence, Judge?
Just to be clear, we skipped, there was no introduction for 11, correct?
I haven't heard that yet. no.
Okay.
No.
And for 12, there is no objection from the defense.
Okay.
All right, B12 is admitted.
Can you tell us what Exhibit 12 is? What is this handwritten document?
This is a actual how much I owe from Mr. Rai.
Okay. And is this something you gave to Mr. Ray?
No, this is because I need to pay the rent. Otherwise, landlord is terminate my lease. That's when I pay the rent. I need to pay the gas bill because this time Mr. Ray run the store. He's the manager. He have to do the paid all of them, but he's not paid it. But if I not paid the bill or rent, landlord terminate my lease. That's the reason I pay this amount. And he say he arrange the money and he give to me,
So-
but he not pay. He not paid it.
When did you create this list?
This list I'm created when is the before the he left the store.
Before he,
And I am sitting with the Mr. Ray couple of time in the store, and we make this figure. I have his handwriting too. This how much money he's not paid it, rent he's not paid it. I have his handwriting too.
which of these lines is his writing?
This is my handwriting.
Right.
I am did it because I am paid this money. Otherwise, my store is the terminate from the landlord.
Now, isn't it true that Mr. Ray never agreed with these numbers?
Mr. Ray agree. He paid it.
He paid these numbers.
No. He said he paid. He want to pay it, but he not paid it. That's reason I am waiting. I think I believe him. He owe this money and he paid, but he's not idiot.
So
And he sent me the letter.
you never actually gave this to him, though.
Yeah, he have this paper
This
before.
paper?
Yeah, he have
When?
before he meet the store. He have this paper.
Before you fired him, in other words.
I have not fired him, never. I say this, how much money I owe you, you paid, you run as like before he's a manager. Same thing. We can go to the lawyer, we do the agreement, operating agreement, and you lease it. You run it. But he not did that.
Let's go to exhibit 16. Tell us about this shooting. 16, I'm sorry. Page 59. There we go. Scroll up a little bit. Nope. There we go. Scroll up a little more. Tell us about this shooting.
Basically, I don't know how is the shooting. This time, maybe Mr. Rai is there. This shooting, I don't know anything for this.
So this is February 21, 2024.
February?
That's the date that it was sent to you.
It's not a shooting. They are asking, landlord asking for the,
Do you recall this?
now this is I think I am not, can you go a little bit down, please? Oh, this is for my landlord. Landlord asking for the AB coverage for the insurance. This is that.
Okay.
But I have AB coverage in my store. This is for coverage for AB, battery and asphalt and battery coverage. This is for insurance.
All right. Let's go to exhibit 17. This is the letter that I sent to you. I think you referred to this a couple times. This is dated May 17th, 2024. Can you confirm that you got a copy of this letter?
Yes, I get copy of
And
this.
is this true and accurate copy of the letter that I sent?
Sorry?
Is this a true and accurate copy of the letter that I sent to you?
Yeah, I get this copy.
Okay. Your Honor would like to tender exhibit 17 into evidence?
No objection.
Submitted.
I want to talk for a few minutes just about payments. We've talked at length about the initial payments, the $200,000. And then there was also an initial payment.
Objection, the testimony was that $200,000 was not paid, that it was $195,000. I just want to be
You're
clear.
correct.
All right.
No problem.
Your testimony was that $195,000 had been paid, correct?
Yeah.
I'm sorry, you're
It's okay.
correct, counsel. And then after that, there was also a payment of $4,750.43. Is that correct? Do you recall getting that payment?
What is that? I don't know this. Do you have a copies there? I don't know.
Okay. Yeah, if you want to go to Exhibit 21, which is page 66. Okay,
Okay.
you see check 1372 at the top right-hand corner. That is Your Honor would like to tender Exhibit 21 into evidence?
We would object, Judge. There's no foundation, but I think he's going to have to get this in through his own client.
Okay. So you agree that you got $25,000 in two payments from Mr. Ray, right? $25,000 each, two checks, right?
Objection, the testimony was that he didn't recall if it
Yeah,
was
we
50
did-
in one check or 25 in two.
I mean, he did cover that in his previous testimony. If you've got something new to ask him.
Okay. Isn't it true that Mr. Ray paid $31,750.43 in other payments to you?
I need to break down. I need to see the breakdown. Otherwise, I cannot. Only for he pay 25,000 for the 5,000 per month forfeit. Other not any payment he's not did that. Only for $25,000.
Judge, if I may, I hate to be a stickler, but if it's not going to be admitted.
I mean,
at
I was
this
about to point
time,
it out myself. We could
21 should
take
be
it off
taken
the-
down. Yeah, thank you.
Yeah, and just going forward, before we would display something on the screen, let's wait till it's admitted, okay?
Makes sense, Judge.
All right. Think this might still be part of it, or?
Go,
good.
yeah, going back to Exhibit 17.
All right, that's where we left off.
That was the last document admitted. So isn't it true that you never issued any share certificates in Nahar Investments to Mr. Ray?
I don't understand what is that.
Did you issue any stock certificates?
No.
Right.
No stock certificate.
And you did not issue any membership shares to Mr. Ray?
No, because we have a agreement, but I don't do anything without agreement. Whatever is the agreement we have, I am follow that.
And you never gave Mr. Ray access to the bank accounts, correct?
He have a writing, he have everything. He write the check and he deposit the money, the account, everything he did it.
Right.
He know everything, the bank account.
But he could not access the online bank account.
He access, but I don't know, he forgot or something, I don't know. But he deposit the money, he's writing the check and signature the check.
And you never opened up a joint bank account with his name on it, right?
We do the joint account in the Metro City Bank. That time is Metro City is some problem for our coin is busted. Is close the coin. This time we need to close the Metro City Bank account, and then we open the Chase Bank. But unfortunately, when I open the Chase Bank account, I'm going to the sick. I'm get the single, and I am in the hospital, and I am the house in the 3-4 months. This time I cannot do anything. You see my here, I am get the single. That's reason is this time I am not a corporation, and he don't put the money, he don't pay the rent, he don't pay the gas bill, he don't pay the electrical bill, he don't pay the water bill, he don't pay the taxes. for the property tax, he don't pay that. He don't pay the storage bill.
So when the COAM license was suspended, you agreed to suspend the payments due from Mr. Ray, right?
What do you mean?
So when the COAM license was suspended for 12 months,
Yes.
you agreed that Mr. Ray didn't have to pay you for that 12-month period.
What
right?
is that? Who is not paid?
Mr. Ray did not have to pay you the monthly payments.
No, he don't pay. He don't pay a long time. He pay only for the $25,000. That's it. No more. It's 21 month. He pay only for the 25,000. That's been 5 months. He pay only for the 5 months.
But did you agree to suspend the payments
No.
because of the COAM?
No, I don't. Whatever is list, I am follow the list. That's it.
And after you fired Mr. Ray, the COAM license was reinstated, wasn't it?
Objection.
I am not
He
a-
already
Hold up,
stated,
hold up.
he already stated I didn't fire Mr. Ray. So there's
Sure.
no evidence in the record of anybody firing anybody.
Okay. I guess the argument is, or excuse me, the objection is.
Assumes facts not into evidence, and it's contradictory to what's
All right,
already been
understood.
stated.
All right, overruled. If he can answer the question as if he recalls it.
So after you fired Mr. Ray right before the COAM license was, or you terminated Mr. Ray right before the COAM license was reinstated, right?
No, I am not a fire Mr. Ray.
Okay. But the date that his management ended was right before the COAM was reinstated, right?
No, after a couple of months, I think the 4-5 months. I think more than that, 5-6 months. 6-7 months, the again coming the COAM license. I think 6 or 7 months. I am not sure exactly. November, December, January, February, March.
5 years, maximum.
Maybe 6-7 months. 6.
Close to, like, it was like 40 to 45 days was remaining to like reestablish the COAM license.
So is it true that the COAM license was reinstated in early January?
You should give us a year.
I'm
Counsel.
not 100% sure. I need to see the record.
We could just get a year, I think, in that in
Oh,
your
okay.
question.
That would be January 24, right? Yeah.
January of 2024, is that correct?
I'm not sure. I need to check.
Okay. And-
Maybe February, March, this type. I'm not 100% sure.
Isn't it true that the COAM license being active accounted for 50% of the store's revenue?
Sorry?
The COAM license accounted for 50% of the store's revenue. Is that right?
No, it's not true.
So when the store lost the COAM license, revenue went down 50%?
No,
And so when the
no.
when the store got its COAM license back, revenue went up 50%, right?
No.
But COAM sparks more than just machine revenue. It also generates convenience store revenue, right?
Yes.
Increases sales of Coca-Cola, right?
Sorry?
It increases sales of Coca-Cola when people are playing the machines.
Yeah, it's a, this is extra revenue. This grocery revenue, gas revenue, and COAM revenue. This is a extra, little bit more.
I have nothing further of this witness, Your Honor.
All right, members of the jury, does anyone need to take a break, or feel free to stand and stretch in place? Otherwise, we'll by show of hands, does someone want to step out for a couple minutes? Okay, let's take a quick break and let us know when you're ready to resume.
Do you want me to say?
Just show hands.
Leave.
Mr. Khan, you can step down just for a minute.
Okay, thank you.
You can leave the notebook out there.
Zoom.
I guess you can't. do it
I
all in
think
1 hour.
yeah, I do. No,
If you can.
the whole thing. About just the things that.
Good job to get out all our exhibits. too.
Yeah.
All right, anything on behalf of the plaintiff before we recess for about 5 minutes or until the jury gives us that light?
No, sir.
Anything on behalf of the defendants?
As a matter of housekeeping and keeping everything fluid, based on the hour, my recommendation would be, I do believe I can ask questions to Mr. Khan that are only directly on point to the questions that were asked by Mr. Collins, such that if we recess at that hour, then tomorrow I can resume my questioning of Mr. Khan as to what would be considered sort of my direct examination and get in the rest of our exhibits, so on and so forth.
But you would do that after we rest, right?
No, what the judge,
I'd originally said, why not just do it all at once so he's not stepping down and then getting back? I guess you're saying it's cleaner since just because of where we are in the day.
yeah, I feel
Just
like if
keep
I,
it divided.
yep, I feel like if I had an hour, I could get in the questions with Mr. Khan that are only in regards to what Mr. Collins asked and just limit it to that scope. And then anything that's outside of that, in essence, if you would like to do it the way you said, I could start that in the morning.
And then we would have another chance to cross-examine him.
I mean, there's going to be a recross and redirect. So, I mean, there's a lot of back and forth here at play. So,
Otherwise,
Yeah.
my only other suggestion would be if you just want to end it for the day and just say, everything that I'm going to ask of Mr. Khan, including rehabilitation as to any questions that Mr. Collins asked, I'm more than happy to just start fresh in the morning as well.
sure. Any input from the plaintiff?
I sort of like the first idea of addressing everything that I asked now. That way it's fresh in the jury's mind, and then tomorrow you sort of get a clean start.
All right. Well, we'll. I mean, I know there was a lot of topics broached, but we'll see how we do, and we can just plan on that plan of attack for our final hour here. Anything else?
A quick question, Judge. Are we allowed to bring water into the courtroom?
That's not a problem.
Okay, good.
That's fine.
Okay, yeah, I realized I had a Coke and then I saw the sign.
Saw the
and
sign,
I just wanted
yes.
to make sure.
Well, it may say something about sodas or something, but I'll.
Thanks for the general. public.
Yeah, that's fine
okay.
for attorneys
All right.
and associated parties. That's we
All
have an exception. Anything else?
Yes, sir.
Okay, we'll be in recess for the next couple minutes.
Thank you, Judge. Yeah, let's step aside.
I mean, I'm just trying to help out for the timings.
No ways. I don't think so.
Okay,
No, I think it's you're going
done.
5:00 or,
I've only addressed these notes.
you know, right, and then.
And then tomorrow is like as if it was my case in chief
Yeah.
and we do the.
And then he goes, if I
Fine.
go, you can go again. He
Okay.
goes last.
Okay.
That's all. Makes sense.
Ready? This is what I was telling you in my office 1,000 times. You heard the lawyer in the opening say what he wants is to undo the deal, right? He wants the money back, right? Because he's saying that he was like duped into the deal, right? If that's true, then all this stuff about what he paid, what he was supposed to do, none of that matters because that would only matter if he was saying that he was an owner. Remember how I talked about the difference
Yeah.
between like undoing the deal versus I'm sticking with the deal, but somehow it was still damaged, right? His lawyer is saying to the jury, I want you to undo the deal, right? Put the parties back to where they were before there was ever an agreement, right? Well, if he's doing that, 90% of the questions that he's asking aren't relevant anymore. They would only be relevant if he was saying, I'm sticking with the deal, right? And these are the things that you screwed up on. Did you see the difference? Undoing the deal would have to be like my restaurant case I told you about. Oh, I was shown all these fake profit and loss statements, and then I signed to buy the restaurants. And then after I bought the restaurants, I realized those P&Ls were, you see what I'm saying? That would be how to undo a deal. Half of this shit.
I am open.
You are, just remember when you can, like, don't ramble, just end it. Just end it. Okay? Now, here's the stuff we're gonna address, okay? All right. So what he's trying to get at is, explain this to me. Between the purchase agreement and the operating agreement, did he have a copy of that
before he went to Supo's office. He did? Did he, did Supo or you show him the purchase agreement and the operating agreement
Yeah.
before he went to Supo's office? Or
No.
he saw it
All the time.
for the first time at Supo's office?
No, we go first time
Mhm.
and we talk to the Supo, then this is our deal. He write down, he prepared the paper, then we going to the signing the list. He read it.
Okay,
and sign.
so first you had a meeting to go over the terms.
Yeah,
Then it took time for Supo to draft it. Then later you guys came back
yeah,
to actually do it.
yeah.
Okay. Now just between you and me, for the purchase agreement and the operating agreement, before you signed, did you get to see it?
No,
So you never saw it either.
No.
You never
No.
saw it and he never saw
no,
it. So you had the meeting, you told Supo what to write. That's done.
Yeah.
Then like a week later or something, Supo says, I'm done. And
Yeah.
then you guys go together. Time. And he's seeing it for the first time.
this is second time.
Counselors,
Yes.
we're live on YouTube and you're not muted your microphone.
Oh,
Okay.
You want to do that?
Going to go outside.
All right, they went far. You can go summon our parties here. Yeah, if you could just do a sweep of the hallway here. All right, let's go back on the record. Jury appears that they're ready to resume and all parties and counsel are present. So Deputy Scott, I'll ask you to retrieve the jury unless anyone has anything to raise. Seeing none.
Make your comment about heat on this narrow scope of topic. Do you want to?
Bring that jury up.
It's my understanding, Judge, that in the format that we're under, since he was called for the purposes of cross, if I limit my questions to the scope that we discussed, he will not have an opportunity to do recross on Mr. Khan. Is that correct? He can only cross him tomorrow when
I mean, I generally allow, no matter what order, no matter what witness, parties two passes at the witness.
All right.
So it'll be confined to the things you bring up or clarify.
Okay,
But I do give folks another pass.
understood.
All
Thank you.
right. Deputy
But-
Scott, can you hear? Oh, sorry.
But when you say confined, I mean, I would think that I would normally get a chance to recross anyway, so it should be, I can cross him on anything tomorrow.
When he
right?
comes back.
Tomorrow.
Sure.
yes, Tomorrow,
He's
yes.
saying for the purpose of now,
Oh,
assuming
for now, yes,
assuming
tomorrow.
we get to redirect and
Tomorrow,
recross. and-
certain, 100%.
All right, Deputy Scott.
Yeah.
Thank you, Deputy Scott. Please be seated, everyone. At this point, members of the jury, the defense counsel has the opportunity to examine their client on the matters covered during the previous examination. So with that, Mr. Khan, if you could retake the stand, and I'll remind you that you remain under oath.
With the page number. That we're-
Laura's hand on that.
Okay.
You want her to pull up the?
Yeah, just because it's already been published, so can you go to plaintiff 4? Page 4, thank you. Hello, Mr. Khan.
Hello.
For the purposes of today, I'm just going to address some of the direct questions that Mr. Collins had for you a moment ago. Earlier, there was discussion about how this attorney came to drafting the purchase agreement and the operating agreement. Do you recall that?
Thank you, sir.
Being asked about that?
Yeah, this
Okay. Did you have a meeting with Mr. Ray and Mr. Chan, the attorney, where you told Mr. Chan an outline of what your agreement was supposed to be?
Yeah, we are go together and tell them that this is our condition. This we want to that is our agreement, and we are left together.
And then roughly 4 to 5 days later, did you receive communication from Mr. Chan that he had completed drafting the documents?
Yeah.
And did I hear you testify earlier that you actually went back to Mr. Chan's office together with Mr. Ray?
Yeah, I am going to with Mr. Ray.
Okay. So the purchase agreement and the operating agreement that you signed, you saw it for the first time at that second meeting, correct?
Yeah, we.
Yes. And likewise, Mr. Ray was reading it for the first time at that second meeting.
Yes.
At any point in time, did Mr. Ray ever say that he wanted more time to review the documents?
No.
Did he ever say, I'm not comfortable being here, I want to get a lawyer before I sign these documents?
No.
Now, going back to page 4 of Exhibit 1, do you still have that notebook? If you can go to page 4 at the bottom, plaintiff's
Yeah.
Exhibit 004.
Yes.
Okay. Earlier,
On page
Mr. Collins, second. Thank you.
made note of this section that's underlined. Do you see that?
All right, just hold tight for a second. Do we have someone join the Zoom who may not be muted? All right. Is it still the witness stand? Okay, we're good. You can proceed.
Do you see that underlined portion in the middle with all the underlined words in the middle? That says against the advice of closing attorney on page 4. Are you on page 4?
Yes,
Okay. You see that underlined passage?
yeah,
Okay. So were some of the checks that Mr. Ray gave to you post-dated or dated in the future?
yes,
Okay. And you ultimately agreed to accept that?
Yeah.
Okay. And this passage makes clear that if those checks were dishonored, then there would be no deal, correct?
yes,
Now, to be clear on what you stated earlier, do you know one way or the other if Mr. Ray left Mr. Chan's office with a copy of the documents that he signed?
I am not sure, but I take my documents, my part.
Thank you. Okay, page 7, please, at the bottom. Okay, if you would, please turn to page 7. And we're going to look at subsection D, which Mr. Collins discussed with you earlier. Now, this paper that we're looking at is still part of the purchase agreement, correct?
Yes,
Okay. And although this says if Mr. Ray defaults on the purchase agreement, you have the right to take possession of the business immediately, you didn't do that, correct?
yeah,
All right. And at no time, well, have you ever at any time claimed that Mr. Ray does not own 49% of this business?
no,
Have you simply reserved your right to collect the remaining purchase price money from Mr. Ray?
yeah, I'm asking a lot of times.
Okay. If you would, please turn to Exhibit 12. Now, between page 52 and 53, I'm showing 53. Can you flip to 53 as well?
Yeah.
Thank you. All right. I just want to make sure I understand what you stated earlier to Mr. Collins. Was this a draft that you made in your own handwriting?
Yes,
Okay. And is this a draft of what you were claiming would be owed by Mr. Ray if Mr. Ray had paid everything he was supposed to pay to you and your company between the purchase agreement and the operating agreement?
this is a rough idea. I provide to you. This is a rough thing. This amount.
Right. But to be clear, this estimated sum of $558,000, is this meant to demonstrate a grand total of what Mr. Ray could possibly owe based on all monies from the purchase agreement and the operating agreement?
Yeah, I write down that way, but it's not a finalized, this draft. And I give another one, this is a final. This.
And to be clear, you're acknowledging that some of this money has been paid by Mr. Ray.
Yeah,
Okay. We already talked about he paid some of the purchase price, right?
yeah,
And we talked about the fact that he did pay some $5,000 monthly payments to you when he was a manager.
yes,
And he did pay some bills that were owed by the company while he was the manager.
yeah.
Okay. Now, you're 51% owner?
Yes.
Did you ever make something called a stock certificate for yourself?
No.
Okay. So it's not as though you have a document called a stock certificate and Mr. Ray doesn't. Nobody has a stock certificate, correct?
I think so.
Okay.
I have not did that.
But at the end of the day, once again, you're acknowledging that Mr. Ray owns 49% of Nahar.
No, he's a 49% owner.
Okay, thank you. Now, if the business operated at a net profit, would Mr. Ray be entitled to 49% of that net profit?
Yeah, previous, this, he's managing time, whatever is profit, he take it.
Right.
But November, after November, is any profit, he gonna be 49% owner.
Well, let's unpack that really quick. So under the management period, he would get all the profit as long as the overhead was paid for and your $5,000 monthly payment. He would get the balance. As long as he pays for all of the overhead and your $5,000, whatever the net profit is, he gets it.
Yeah.
Right. Okay. But then separate from that, even after he's not a manager, whether it was cut short on November 11th, 2023, or even if he had finished his management period of January 31st, 2024, after his time as the manager ended.
Objection, Your Honor, leading.
I think I need to wait and hear the end of the question here. You can continue.
Would Mr. Ray still be entitled to 49% of any net profit if there was a net profit?
Yes,
Okay. Now, did Nahar file taxes for 2022?
yes.
Do you recall exactly what the net profit or net loss was for 2022?
I think I think it's 17,000 or something, or $2,000 profit, I think.
Okay.
2,000
May
some.
I approach? Just so I can
I
show
think
some.
I don't have a, yeah.
question?
All right, if you can show it to opposing counsel, and then you may.
Okay. I'm not asking for this to be admitted.
Motion also talked about like testimony.
Does that refresh your recollection
17,000.
of the net loss for the company in 2022?
I think, I think, so, yeah.
All right.
Your Honor, I'd have to object to this document. Can we approach?
You can approach, sure. All right, so Mr. Khan, once your memory has been refreshed, if you can put that document aside and listen to the next question that's asked.
So, does that refresh your recollection
Yeah.
of what the net loss was for 2022?
Yeah, $17,899.
Thank you. You can put it down. Did Nahar file taxes for 2023?
Yes,
Do you recall what the exact
I think
profit was for 2023?
2000 something, 2000.
My approach.
You may.
Let me know if this document reflects your refreshes your recollection.
Yeah, oh, sorry, 4,563.
You say $4,563?
Yeah,
All right, you can put it down.
sorry.
And did Nahar file taxes for 2024?
Yes,
Do you recall exactly what the profit and loss was?
I
for
think 11 something $1,000.
Show your document that might refresh your recollection. Does that help?
Yeah, sorry, 7,202.
All right, you can put it down.
7,202.
So to be clear, between 2022, 2023, and 2024, Nahar has operated at a roughly negative $6,000.
Yes,
So there are no profit distributions to be made to either Mr. Ray or to yourself.
yes.
All right, I'll take those back, and that's all I have, Judge, for the purposes of today's conversation.
Understood. Any redirect on those, or recross rather, on those points?
Your Honor, I just assume recross on everything tomorrow, if that's okay with the
All
court.
right, understood.
Thank
All right, members of the jury, I believe we have reached a stopping point for today. I know we've covered a lot of ground, been a long day. Thank you for your continued attention to this matter. So we will, as I'd mentioned before, resume at 9 o'clock tomorrow. Please plan accordingly. That shuttle may be running a little behind, but we want to start right on time so we can make sure we can get right into it. If you have any questions for me or any concerns, feel free to raise those now. But if not, we will see you tomorrow at 9 o'clock. Please don't discuss the case with anyone, including amongst yourselves or with any family members, and don't do any research about the case. Everything you learn about it happens right here in this courtroom. We'll see you tomorrow morning. Mr. Khan, you can step down.
I mean,
You can step down, sir.
I was- And those two, he never did a motion compel. I would go, if I was him, I'd go ape shit regardless. I'd be like, there's no way. Do you want me to?
All right, thank you, Deputy Scott. All right, before we would break for today, we had a bench conference. Obviously, the court reporter can't transcribe any of those. So I don't know if plaintiff wants to preserve anything or bring this up since it may come up again while we have this time.
Well, yes, Your Honor. This objection is all about what we did in our motion limiting, which is they're bringing in documents that they did not provide during discovery. And more importantly, this is all very germane to the case because this is about whether or not Mr. Ray participated in the profits and losses of the business. So I'd like to get a copy of these tax returns and get them redacted, and then we'll ask Mr. Khan about them tomorrow.
I mean, I do think that from what he refreshed his recollection on, you have a right to. Anything he had on the stand with him, you have a right to inspect. And I certainly don't think that using the witness recollection method can be a way to circumvent, what is would otherwise be introduced as a document. That being said, the grounds for your motion, we're kind of raising 403 grounds. I don't think that's ever going to be really a valid way to exclude discovery that hasn't been turned over. We never had a motion to compel. Y'all never went that route. And the case law says that to exclude relevant evidence is going to really create some issues here. So if you need, I'm not hearing motions for mistrial or postponement based on these. I think we're just going to have to deal with it as it comes.
I'm really not looking to exclude the documents. I want to use them.
Yeah. So to that end, I'll let you respond to anything and everything. But what I want to avoid is if during your direct, there's like an extensive accounting where he's just being refreshed one document after the other. That's what I'm trying to avoid. This was fairly limited, pretty mild, and I think he's going to be able to review those documents, do with them what he will. So to that, any response from the defendants?
No, and this may be a reoccurring theme. Forgive me if I'm missing something in this regard, but on the one hand, I'm hearing opposing counsel say this is all about this gentleman not getting profits. But my understanding now is we are locked into a theory of the case where the relief that the plaintiff is seeking is no longer a breach of contract where he's owed money damages from lost wages or profit distributions, that now we are in the land of unwinding the deal.
Rescission. Yeah.
So quite frankly, I don't even understand the relevance of how much Mr. Ray or Mr. Khan could have made, should have made, because that's no longer an issue of the case. The only issue now is, in my estimation, is there going to be evidence that is propounded by the plaintiff to demonstrate a prima facie case and ultimately preponderance of the evidence for grounds for rescission. So I don't even understand how money's being made and what was lost is even relevant anymore.
So, well, and we can dive into that too. I mean, just as an initial matter, I think what we were focusing on was more of a discovery-related concern and the motion in limine. And so to those points, do you have anything to add?
No, and I mean, if anything else, if we need some sort of a safety net or security blanket, I mean, I'm happy for the judge to give a curative instruction that in essence says, you know, just as a reminder, any documents that were used to refresh somebody's recollection are not the evidence, it's the testimony itself, as you said in the sidebar. I mean, that's the only weight on the scale is what this gentleman said the loss was, and then for the other 2 years, what the profit was.
I mean, fair enough. But what I also alluded to was, you know, again, I believe it's either 612 or 613, but whenever you're showing them something, he's going to have the ability to look at it. And so again, just in the interests of kind of preventing us having to grind to a halt, I would say that anything that you anticipate needing to refresh his recollection on should be provided to him well in advance of the testimony.
And this is it.
Okay, well, there you have it. So as it relates to the more substantive things you raise, that is something I'll be taking a good look at tonight with the charges you've requested and the, you know, theories propounded by the pleadings. I guess if I was to say it an alternative way, your position is the claim brought here was for breach of contract and rescission was never requested as a remedy or separate claim. So is that not even you're saying not a legitimate avenue for the jury's consideration?
Very close, Judge. I would say, and I alluded to this in my opening statement, that on the one hand, count one says breach of contract. Now, the only dollar figure that was presented for that breach of contract claim, ironically, however, was the purchase price. Now, put a pin in that because count two is fraud. Now, I would contend that that is not common law fraud, it's fraud in the inducement. In other words, the enumerations go into the depth of Mr. Ray was misled as to the historic financial performance of the company. In essence, he was duped into the deal. Now, to me, that can only mean one thing. That's fraud in the inducement. So we are either in the land of we want to unwind the deal, we want to rescind, or we want to keep the deal in place and sue for the consequential damages that flow from that fraud. However, in opening, the first door was entered into, which is we want to unwind the deal. That's the relief we're seeking. So to me, it's really two parts. Number one, there should not be any exploration anymore into breach of contract because
We're dealing with fraud, number one, and number two, we're not dealing with a decision within that fraud of, I want to keep the deal in place and then sue from the damages that flow from that. We are in fraud and we are in rescission. So
Would this not just be an alternative remedy and they're allowed to pursue and elect their remedies after judgment?
they're not, because even if we hyper-focus on the fraud and the inducement, the law is clear, you have only two options. You announce to the world that I've been bamboozled, I want to unwind, I want to go back to where I was before, or I want to keep the deal in place and I just want to sue for the damages that naturally flow from that. Now, the reason, so that's one thing to consider.
As
but-
a best, I guess, as opposed to fraud with solely confined to being within the agreement itself.
Right, like, hey, after I bought this restaurant, this guy lied to me about all these different things, and as a result of that, I was supposed to get $1 million more in my distributions and I didn't. So we're not in fraud post February 11th, 2022, the way.
Or within the agreement itself.
Right, the way count two is articulated, the way the PTO is articulated in their succinct outline, which I believe is section 6, it's fraud in the inducement. So, like I said, to me, there's two issues. One is, are you unwinding or are you sticking with the deal and just getting your damages that flow from that? Well, we know we're unwinding. And if we are doing fraud in the inducement and unwinding, you cannot have breach of contract. There is no contract anymore. So that's why I had that slide that, frankly said, I'm hearing incompatible. It would be one thing if it was, I'm pleading for trover and in the alternative conversion or replevin. I mean, I understand that there's alternate theories of recovery if someone takes my bicycle and the issue is whether it was the money or the bike. I understand these are not in the alternative. These are, you got to pick the red pill or the blue pill.
And the pretrial order, as kind of proposed, doesn't really say that definitively one way or another, does it? I mean,
Well,
it maybe alludes, but does it really come right out and say which type of fraud it's been locked into?
I mean, I would just say, does it, unless Mr. Collins, frankly, is saying, going to change what he said in his opening, which is the relief that we're seeking is to unwind. That's the only thing that's practical or reasonable, I believe, is to unwind the deal, put the parties back to where they were. I think that's settled at this point.
Okay, well, let's see if we have any clarity here, Mr. Collins.
So Judge, I think as we have delved into this case, it's become clear that Mr. Khan did not ever do the things he was supposed to do to perform under the contract. So I would argue that could be a breach of contract where our damages are the money that we have paid to Mr. Khan. And the whole idea is that Mr. Khan did not provide anything that he was supposed to provide. And in addition to that, he bamboozled Mr. Ray. So I think that we could absolutely bring.
Well,
some
let's drill down. There are
Okay.
many different ways someone can be bamboozled. When did this bamboozlement occur, and what form did it take?
I think that at this point, I have not heard Mr. Khan testify that he was, that there was fraud in the inducement. I suspect the evidence is going to show that he never intended to do the things he's supposed to do, add Mr. Ray to the bank account. But Judge, at this point, we don't know what all the evidence is going to show. So I would say that there's still a lot of questions. There's what I think it will show, what I would like for it to show. But I certainly don't think that there is a decision at this point in time.
Sure, if we're not willing to kind of narrow that at the point, but I think it's still worth discussing to see if we're all on the same page as it relates to the law. I think, opposing counsel's point was that if this is a fraud in the inducement theory, where we're not talking about fraud after the agreement or even fraud within the agreement, it's just what led up to that point of signing, that the case law is fairly explicit about electing remedies before it gets to the trier of fact. And
I think our position is that it was maybe some fraud in the inducement, but certainly it was fraud afterwards. I mean, it was his decisions after the contracts were signed that where he did not put Mr. Ray on the bank accounts, did not share critical information with him after the contracts were signed.
And I understand how that would be a breach if that's
Right.
a material term of some kind, but him just not doing that thing, do you have evidence that shows the intent for him not to do that thing of when that was formed or why that's after the fact or I guess
I think that Mr. Ray's testimony will provide
Okay.
evidence along that way about his efforts to get the things that Mr. Khan was supposed to get to him. So I think Mr. Ray would definitely testify to that. But I would maintain that we should be able to maintain both a breach of contract claim and a fraud claim. I don't believe that it is an either or situation.
The charges you submitted, I haven't looked at them yet, but I was going to tonight. What kind of, was it just a pattern charge generally on fraud?
They're all pattern charges.
Okay.
Yep.
All right, sir.
Okay, thank you. So again, this might be helpful. Okay. On the issue of, are they locked in now to fraud in the inducement? And based on what Mr. Collins said in opening, this notion of unwinding the deal, right? I mean, the broad claim in the complaint says defendants misrepresented the facts and circumstances related to the operations of the business, including the historic financial performance of the business. Okay. Now, there's only one way to unwind. Unwind is a synonym for rescission. He said that the only thing that the jury can do based on my client being a scammer is to unwind the deal. If it's breach of contract, you can't unwind the deal. That's number one. You're sticking with the contract. Number two, if they want to change course and say that my client breached the contract, now the problem is they can't say that their measure of damages is all of the money that they paid into the business. Because if it's a breach of contract, the money that he paid into the business was the purchase price to own 49% of the business. The only damages that can naturally flow from the breach of contract would be wages, money earned as a worker, and or money that was owed from profit distributions as a 49% owner. So once again, it's not pleading in the alternative. These are irreconcilable theories of recovery. So I just go back to what the jury heard. The jury heard unwind.
Let me stop you there because, you know, they're advised openings are not evidence and sometimes the evidence doesn't come out as you expect it. So I don't take openings as locking someone in. Usually the pretrial order is what locks us in and you know, it raised all the claims here. But, you know, after we get to directed verdict stage, that could be where the issues are narrowed.
Well, I have terrible
So,
concern
yeah.
that, you know, no matter how diligent and hard that the jury works at this, they are going to need to understand that if this gentleman wants to unwind this deal, there is only one route for that and one measure of damages for that. But if he thinks that this is a contract case where my client, you know, breached section 15, 25, and 26 of the operating agreement, that's fine. But then that measure of damages is not give him all the money, because you can't be a 49% owner of the company and get all your money back.
Sure. So what would assist me is going down that line of case law and finding just procedurally when that fork was in the road, when it had to be made.
All right.
And we can see how that would apply here. But Mr. Collins,
Yes,
anything
Your
else?
Honor, I would just say that if the contract called for him to give Mr. Ray 49% of the business and he did not do so, that is a breach of contract. And therefore, the measure of damages would be what he paid for that 49% that he did not get. So therefore, I think maybe it was inarticulate for me to use the word unwind the business, but I think the point is still valid. He paid for 49% and he didn't get it.
Sure, but what I think the core of the argument here is that, and there is, you know, a lot of cases on this point and a whole line on it about when we're dealing with fraud in the inducement and breach of contract, that those are irreconcilable. And there's variations of fraud that maybe get accepted from that, but fraud in the inducement is kind of a red line there. And so
I think it's
That's-
also important to note, we've stipulated he is a 49% owner. There's nothing in our answer and counterclaim. There's nothing in any interrogatory response. There's no testimony. Nobody has ever said that Mr. Ray is not a 49% owner.
when you
Except
say
there's tax returns.
when you say you've stipulated, is that
Well,
in the pretrial order, or you're just saying you haven't contested that, or what?
It's never been a bone of contention. And we would be happy to stipulate that he is a 49% owner.
Sure.
But again, if he's saying he's not a 49% owner, then okay, he can pick that route and try to get his money back by saying, I wasn't a 49% owner because I was lied to about the historical financial performance of the business before I entered into the agreement. That's fine. But then we can't go into the breach of contract stuff. I mean, and if it is the breach of contract stuff, because he is a 49% owner, then the damages aren't going to be what he paid. It's going to have to be
No,
some other measure.
I understand the point, and if it comes down to it where it does seem like the only evidence is fraud in the inducement, then, you know, we may have to remove one of these theories from the verdict form, and that's just what's there for the jury to argue and consider. We're not there yet, though, and so we'll have a lot of ground to cover tomorrow on these points. I think the charge conference is going to be very important to that end. So bring your case law. Feel free to email it to us so that we can get a head start on it. Otherwise, let's see you back here ready to go at 9 o'clock, and we'll resume with the plaintiff's evidence. Anything else we need for the record today on behalf of the plaintiff?
No, sir.
On behalf of the defendants?
No, sir.
All right, we'll be in recess.
All right.
Is that what it is?
Yeah, Your Honor, just real quick too,
We'll probably have the record. We might have lost our court reporter.
I was just gonna say, our non-pattern charges 3 through 5 address this issue
Okay,
as a starting point.
we'll be taking a look.
That's why.
Thank you.
Okay. Oh, okay. Thank you. Question.
Yeah.
Let's go to our little conference room.
We can't, I mean, I think they lock up, so coming back. Yeah,
So there's no.
unless there's
other
anything
case.
you need to work on. I think he's more talking about that. Like, you
Okay.
guys show me how. I mean, but yeah, y'all have it.